And then when you look at his needs, so when he was arrested, his the Burnett County Jail had his blood sugar level at one of the ones, which is like a day or two after his arrest, was around 600 and something. That's dire medical attention, and it took them, 3 treatments, of heavy doses to get it to a level where it isn't, you pretty much need to go to the hospital. When he was at the time he was arrested, when he's taking all these substances, he had a diabetes problem that was so severe that he lost multiple toes. And diabetes tends to aggravate or bring on depression. And he'll talk about more in his.
I'm lost in your argument.
Okay.
Honestly, way lost. I get the fact that he has diabetes, and I get the fact that his blood sugar level was skyrocketed to over 600 when he was arrested, and he lost toes because of this. But when he's arrested, and why is that a big deal? Are you indicating or informing the court that you believe that the jail did something wrong?
No, you are. What I'm doing is pointing out that his mental state at the time, in terms of not really having much of anything to live for, and he'll talk about that more, and that now that he's had time in custody, his diabetes has been treated, and he's had time to, because of the diabetes treatment, deal with some of that's lowered some of the depression issues. That's something that can be considered when looking at his future conduct versus his conduct when he was arrested. So I'm not saying, no, Burnett County Jail, because they treat him, may have saved his life.
I think they did say
Right. Now, the reason I say may is because his blood sugar was obviously high when he was arrested, still high. And, I don't know how long he'd have, survived before then, if it would have come down, if he hadn't been arrested that day, if he'd have taken whatever. So no, I wasn't using that to say that the jail was derelict in their treatment of him. Just pointing out that, when he was arrested, he was in very poor health, and that poor health affected some of his choices that led him to sit here today.
So that's what you're saying?
Yes.
Now that he's in good health, he's going to make better choices.
He's more likely to make better choices. I don't guarantee anything, and I think anyone who does guarantee the court anything is,
Yeah, it's always an error. Maybe we don't have a crystal ball.
Right, but it makes it more likely. And then he's talking about the other things that, he said he's done to rehabilitate himself or make him more likely to succeed and not go down the same road if he has a lower sentence than that recommended by the state or the PSI. And I'll leave that in his own words. But I did want to point out that, he's a man who is at least now looking forward to the future. He's saying, I've been, in essence, trying to be like not a father to my grandchildren, but I've had a parental role. So he took some of that time in jail to take some classes to help him do a better job of that. And he's, taking care of his health better than it was previously. And yes, the jail's obviously directed that because they've monitored him. And, if he's released when he's released at some point, whether it's now or several years from now, okay, not now, I'm not going to ask for a release today, obviously. But when he is eventually released, it's up to him to make sure that he follows up and doesn't get himself back to that physical condition that affects his mental health.
And you're bringing me back to other questions, though. He knew of this prior to even getting arrested. He knew he had health conditions. He did know that they were affecting his life and his ability to think properly. And now that they're under control, he's going to make better choices. But he could have controlled that before, went to a doctor before, and got it under control before.
Yes, Your Honor. That's sort of $1,000 question in any criminal case is, why you didn't do it yesterday.
Because he wasn't facing prison yesterday.
Well, and
Figuratively speaking,
right,
yesterday, not literally yesterday.
right, I understand, but I mean, just in terms of, sometimes that access to service that's enforced, does help. I mean, but all right. Right, so what I do is to point out that he does have some motivations, and the court doesn't need to do a 8 to 15-year prison sentence to ensure accountability and to ensure that Mr. Den has something to keep a watch over. This court has tended to use imposed and state sentences more than some of the other ones in which I practice. And, that I'm not saying that's good or bad. In this case, it'd be
Court
good.
does a lot of things different than other courts in our district.
Right. And like I said, I wasn't saying that as a bad thing. And there are cases, including this one, where I think that specific accountability, or where upfront what you're getting, is probably useful. And that's one of the things I plan on arguing for.
You never know upfront what you're getting. A judge has discretion all the time, no matter what, even if they're recommending probation, all the time. You don't know what you're getting.
Yeah. What I meant by upfront is if he's on probation, or at some point, well, if he's on probation and there's an imposed and state, that's different than cases where you go back to the court and then the judge decides your sentence years later. That's what I was talking about, knowing upfront. I was
All right.
right, because I recognize, I've talked to Mr. Den. He's aware, we're all aware that Wisconsin doesn't do the sentencing guidelines like a lot of other states, where exactly, or you almost know what's going to be in most cases. So I was talking
in sentencing, we don't even have the other than early release programming. There's
right.
No good time in Wisconsin for prison.
Right. He's aware that too. So that's what I was referring to, is that where what you're getting, as I was talking about, that if you were on probation and revoked, that he would at least
have a better idea.
Have an idea that's not come back to court and hope I get lucky. It's just, you can see the size of the noose hanging over your head is probably a way to phrase it. Okay. Well, not noose, I was thinking about guillotine, but okay. All right, so.
Or you have the carrot and you do better.
Well, right. I mean, carrot stick, but fear is sometimes a better, you can call it, whether it's fear and motivation, people are motivated by different things. And the carrot is that you're not going right away, as I always look at it.
Carrot is you have the ability to never go away.
Well, yeah, but okay, but that's more of a half full, half empty glass philosophy thing, probably. All right. And the other thing I note with regards to his ability to function under supervision, even in the community, is that in the 2018 case, he did a year of home monitoring and successfully completed that, along with the probation afterwards. And the other issue when we look at it is when we get to protection of the community, there's two ways to look at it. The DA suggested one, that if we throw him in for 15 years, we're protecting other people from Mr. Den.
His argument was actually 10 in.
I said 15.
Oh, you said 15? Oh.
No, he said 15.5. He was arguing for the max.
15.5. Okay, thanks. I wrote it down wrong.
Okay.
15.5.
Yeah. But the other way to protect the community is through supervision of Mr. Den. And, having that deterrence hanging over his head, knowing that, even if you're given a chance by the court to go back to, helping your grandchildren and other things, you have that hanging over your head, that you could set this amount of time. And along with the actions he's taken since being in custody, specifically that he'll talk about more, he's also, as the courts where he also had to take care of his physical property. It had a forfeiture order. And as far as Mr. Den, I know he's through his people, he's taking care of his property. So that's something, a sign where he's showing he's trying to take care of his future and have one. And when you look at whether the people's incentives and motivations, whether they think they have hope is also a factor in whether or not they're likely to be successful versus people who feel like everything's lost and there isn't hope. And like I said, when it comes to protection of community, I think when you look at drug crimes where the person's also,
All right, let's talk about that. In the final stretch of the sentencing hearing for State of Wisconsin v. Michael Den, defense attorney Glenn Keane shifted his focus to an aspect not always front and center in these discussions: Den's health. Keane painted a picture of a man who, at the time of his arrest, was in a state of severe medical crisis, with blood sugar levels soaring over 600 and a diabetes condition so advanced that he'd lost multiple toes. Keane was quick to clarify that this wasn't about blaming the Burnett County Jail. In fact, he credited them with likely saving Den's life through immediate and intensive treatment. His point, rather, was that Den's deteriorating health at the time had a significant impact on his judgment and life circumstances, and that the man before the court today was in markedly better physical and mental condition. Keane argued that the improvement in Den's health, coupled with steps he's taken while in custody, such as enrolling in parenting classes to better fulfill a grandfatherly role, was evidence of rehabilitation in motion. He acknowledged with refreshing honesty that no one could guarantee future conduct. "We don't have a crystal ball," he said, but emphasized that better health and clearer thinking made positive choices more likely. This set the stage for his broader argument. The court didn't need to impose the state's recommended 15 years of initial confinement to protect the community or ensure accountability. That point led to a deeper discussion between Keane and Judge Mogen about sentencing philosophy. Keane contrasted the deterrence through incarceration approach with the concept of accountability through supervision. In his view, the carrot and stick dynamic of probation, with a clear understanding of the consequences if violated, can be just as effective at protecting the public as locking someone away for over a decade. Judge Mogen pushed back lightly, pointing out that in Wisconsin's system, sentencing outcomes aren't always predictable, even with probation. The exchange had a conversational rhythm, with a moment of humor when they swapped metaphors, Keane referring to the size of the noose, and the judge countering with, "maybe more like a guillotine." Keane also cited Den's successful completion of a year of home monitoring and probation in 2018 as proof that he can function under structured oversight. He suggested that keeping Den in the community under strict conditions, with the knowledge that a substantial prison term loomed if he slipped, could provide both deterrence and an opportunity for continued rehabilitation. The underlying theme was hope, arguing that defendants who see a viable future rather than inevitable decline are more likely to succeed upon release. Through it all, Judge Mogen maintained her steady, inquisitive style, probing the defense's points, clarifying intent, and making sure the record reflected both the health narrative and the sentencing philosophy debate. The atmosphere stayed professional and even lightly humorous at times, despite the serious stakes. By the end, the court had a full, layered picture: a defendant whose past was marred by serious conduct, but whose present health and outlook might offer a different path forward if the sentence allowed room for it. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.